Good evening. We have a significant convergence of legal events to discuss tonight. Two distinct storylines that have collided to create a substantial problem for Donald Trump. If you look closely at the timeline, you see a specific pattern emerging. On one hand, we have the special prosecutor who oversaw major federal investigations into Mr. Trump testifying before Congress. On the other, we have a federal judge in New York dismantling a specific legal maneuver attempted by the executive branch. To understand the gravity of this, we need to look at the details, because the mainstream headlines often miss the mechanical reality of what just happened. We are seeing the judicial system and the legislative record being used to document what federal prosecutors and judges are describing as willful violations of the law and abuses of power. Let's start with the situation in New York, because this is a concrete example of the judicial branch stepping in to stop an executive action. A federal judge, Judge Laura Schofield, has issued a ruling that completely invalidates a strategy Donald Trump employed regarding the Department of Justice. The core of this issue revolves around the appointment of John Cerrone as an acting U.S. attorney in Albany, New York. Now, let's analyze what this specific move implies. Donald Trump installed John Cerrone in this position, and almost immediately, Mr. Cerrone began a very specific line of inquiry. He opened criminal investigations targeting Letitia James. For context, Letitia James is the New York Attorney General who successfully secured a massive fraud judgment against Mr. Trump, the case that resulted in hundreds of millions of dollars in penalties. The sequence of events here is critical. Following that loss in court, Mr. Trump's appointee, Mr. Cerrone, began using the powers of the federal government to investigate Ms. James. He issued subpoenas to her office. He utilized grand juries. He essentially turned the federal law enforcement apparatus against a state official who had just won a case against Mr. Trump. However, Judge Schofield has ruled that this entire operation was legally void. She didn't just disagree with the investigation. She ruled that Mr. Cerrone was not lawfully serving as a U.S. attorney in the first place. She stated that the appointment itself was illegal, meaning Mr. Cerrone had no authority to issue subpoenas or run grand juries. Consequently, she voided all the subpoenas sent to Ms. James's office. They are now legally non-existent. To really grasp why this ruling matters, we need to take a moment to explain the concept of the Federal Vacancies Reform Act and the distinction between a Senate-confirmed official and an acting official. Under the Constitution, U.S. attorneys, the powerful federal prosecutors in each district, are supposed to be nominated by the President and then confirmed by the Senate. This is a system of checks and balances. The Senate acts as a filter, vetting nominees to ensure they are qualified and not merely political operatives. However, there is a mechanism for filling vacancies temporarily, often called acting appointments. This allows the government to keep functioning if an official resigns or dies. But Donald Trump has utilized this mechanism as a loophole. By installing acting attorneys, a president can bypass the Senate confirmation process entirely. This means they can put loyalists in powerful positions without those individuals ever having to answer tough questions from senators or face a public vote. What Judge Schofield ruled is that this loophole has limits. There are strict time limits and procedural requirements for how long an acting official can serve and who can be appointed. The judge found that the administration violated these rules with Mr. Cerrone. He was kept in that position without lawful authority. Therefore, the power he tried to wield, the power to compel documents and testimony via subpoena, was illegitimate. This is a profound check on executive power. The judge explicitly warned that when the executive branch bypasses these appointment rules to investigate political opponents, it is acting without lawful authority. She characterized the scheme as an unlawful abuse of power. It creates a legal precedent that simply because a president names someone to a role, It doesn't mean that person actually holds the legal power of that office if the proper constitutional steps were ignored. Now, while this legal defeat was unfolding in New York, we saw a parallel development on Capitol Hill. Jack Smith, the special counsel who investigated the classified documents case and the efforts to overturn the 2020 election, appeared before the House Judiciary Committee. This was his first time testifying before Congress, and his statements were stark. Mr. Smith stood by his investigation, reiterating that it was driven solely by the facts and the law. But the most damaging part of his testimony for Mr. Trump was his clarification regarding the evidence. Mr. Smith testified that the charges were brought because the evidence established that Donald Trump willfully violated the laws, the very laws he took an oath to uphold. Let's pause here, because the word willfully does a lot of heavy lifting in a legal context. We need to break down exactly what willful intent means in criminal law. In many legal situations, you can break the law by accident or through negligence, and the penalties are usually lighter. But willful implies a specific high-level state of mind. It means the person knew what the law required, understood their obligations, and made a conscious, deliberate choice to violate that law anyway. When Jack Smith says the evidence demonstrated willful violation, he is saying that this was not a misunderstanding. He is asserting that the evidence proves Donald Trump did not accidentally mishandle classified documents or inadvertently stumble into a conspiracy regarding the election. He is stating on the congressional record that Mr. Trump acted with full knowledge that what he was doing was wrong. That removes the defense of ignorance or incompetence. It frames the actions as deliberate criminal conduct. Mr. Smith went further, stating that he would have sought the same indictments against any sitting president given that same evidence. This testimony directly counters the narrative that the prosecutions were a political witch hunt. Mr. Smith is putting his professional reputation on the line to say that the standard applied to Donald Trump is the exact same standard that would apply to anyone else. If another president had the same evidence against them, recordings, witness testimony, documents, they would also have been charged. Crucially, Mr. Smith clarified why these cases did not go to trial. There is a common narrative that Mr. Trump beat these cases or was exonerated. Mr. Smith made it clear that is not what happened. The cases were paused or dismissed solely due to the Justice Department's long-standing policy against prosecuting a sitting president. This is another complex term we should unpack. DOJ policy on sitting presidents. This isn't a law passed by Congress. It's an internal guideline of the Justice Department that dates back decades. The theory is that a president cannot effectively lead the nation if they are defending themselves in a criminal trial. Therefore, federal prosecutors cannot bring a sitting president to trial. Because Donald Trump won re-election and became president again, this policy kicked in. It acted as a shield. It froze the cases. Mr. Smith wants the historical record to reflect that the cases ended because of an election result, not because the evidence was weak or because Mr. Trump was found innocent. The legal jeopardy was halted by political circumstance, not by a jury verdict. So, when you look at these two events together, you see a comprehensive picture of the legal reality surrounding Donald Trump. On one side, you have a federal judge ruling that his administration's attempt to weaponize the justice system against Letitia James was illegal and void. On the other, you have a special counsel testifying under oath that the evidence proves Donald Trump willfully committed crimes and was saved only by his office. This creates a permanent record that contradicts the political narrative Mr. Trump presents. He often claims that his appointments are perfect and his legal troubles are hoaxes. But here we have an independent judicial ruling stating his appointment was illegal. We have sworn testimony stating the evidence of his crimes was substantial. The ruling regarding Letitia James is particularly devastating because it exposes a failed retaliation attempt. The intent was clear. Mr. Trump wanted to turn the tables on the prosecutor who won a fraud case against him. He wanted his own appointee to harass her with subpoenas and criminal inquiries, but because they tried to bypass the constitutional rules to do it, the entire effort collapsed. It shows that while the executive branch has immense power, it is not absolute. Courts can, and in this case did, step in to say, "You did not follow the law, and therefore your actions are invalid." Furthermore, the voiding of the subpoenas has practical consequences. It means that any information Mr. Cerrone gathered using those subpoenas is likely tainted. If a future prosecutor wanted to pick up this investigation, they would have to start from square one. They couldn't use the fruits of an illegal investigation. By the time a new, properly confirmed U.S. attorney could be put in place and restart the process, the political window would likely have closed. The Federal Vacancies Reform Act violation essentially killed the momentum of the retaliation. For Donald Trump, this is a nightmare scenario because it strips away the veneer of legitimacy. It is one thing to shout at a political rally that you are being persecuted. It is entirely another to have a federal judge write a legal opinion detailing how you broke appointment rules to target an enemy. It is one thing to claim on social media that you did nothing wrong. It is another to have a veteran prosecutor explain to Congress in detail how the evidence proves you willfully broke the law. These events are now part of the history books. They are part of the legal precedent. Future lawyers will study Judge Schofield's ruling when looking at the limits of acting appointments. Historians will look at Jack Smith's testimony when analyzing this era of the presidency. The narrative that Mr. Trump was simply a victim of politics is being dismantled piece by piece by the very legal system he tries to control. In the end, what we are witnessing is the friction between authoritarian impulses and the rule of law. The attempt to install a loyalist prosecutor to target an enemy is a classic authoritarian move. The court striking it down based on statutory law is the system working as designed. The attempt to claim exoneration when a trial was merely delayed is a political spin. The prosecutor clarifying the record with evidence of willful intent is the truth catching up. These are not just headlines. They are structural stress tests of the American legal system. And as of today, the record shows that independent actors, judges, and prosecutors are holding the line, documenting the overreach, and ensuring that the truth remains visible regardless of who sits in the Oval Office.